gaveling us back into session. We have some guests here that were scheduled to be here at 1 o'clock, and it's now 1:07, so we need to get going. It's the 1 p.m. item on your agenda, request to support the legal foundation of Washington's proposed change to RPC 1.15. We have, I hope, online Catlin Davis from the Legal Foundation of Washington. She's the chair. Also, we have Sean Michael Davis, Legal Foundation of Washington secretary. From the Committee on Professional Ethics, I believe we have the chair, Pam Anderson, and Professor Brooks Holland. We have all these folks? Okay. Yes. Chair Davis, would you like to begin the presentation?
Yes, this is Caitlin Davis from the Legal Foundation of Washington. Thank you for inviting me this afternoon. I would make a polite correction that I'm the executive director. And so while I appreciate your confidence, and I will definitely report to my board the promotion, I am the humble executive director. And unfortunately, due to the schedule change, our board member, Sean Michael Davis, is not able to join us. I just want to say, in terms of updates since the last Board of Governor meeting, how very grateful the Legal Foundation is for the work of the Committee for Professional Ethics and for the Office of Disciplinary Counsel for their work drafting the language and thinking this through, helping move this process forward. The last meeting that you had, the rule change that or amendment that we're proposing intended to benefit legal services for low-income people in Washington state. It will not cost lawyers, the WSBA, or the state any money. And if this rule change is adopted, any revenue that we generate will be distributed to a network of 30 legal aid providers around the state to help remove barriers. I'm happy to answer any questions, although at this point it becomes more a matter of questions for the chair of the committee and for the amount of work into this effort.
Okay, anybody else want to present on this?
Mr. President, did you mean anyone else from the Washington Legal Foundation?
Yes, yes, please.
Oh, okay, thank you.
Okay, any questions from governors? No? Okay, the Council on Professional Ethics, I think they wanted to weigh in on this. Do we have Chair Pam Anderson here? Here, yeah, I see you.
Yes, hi. Yes, thank you, Mr. President, President Tollefson. We do not have a, I suppose you would say, a stake in this. We took our direction at the last meeting of the Board of Governors to work with the Legal Foundation of Washington and especially with the Disciplinary Council to draft a rule that could be considered by the Board of Governors at this meeting. And we have done that. We have sought the significant input and used the significant input of Doug Indy of the Office of Disciplinary Counsel. And we have, as Ms. Davis said, provided a copy of the draft to the Legal Foundation of Washington. Professor Holland is here to answer specific questions about the rule or the proposed rule. He was on the subcommittee that the CPE assigned to this task and has spent quite a considerable amount of time working on this issue. So I'll defer to him for specific questions that the governors might have about the structure of the proposed rule itself. Thank you.
Professor?
Thank you, President Tollefson, governors, other participants. Nice to see everybody. Chair Anderson and I thought it might be valuable if I offered a few highlights from the proposal, because any proposal to amend the trust account rule significantly is an important change to the law for lawyers. And the other subcommittee members and I, Don Curran, as well as Cinda Fernald, think that we hopefully have addressed the concerns that we had been discussing about how to execute this proposal as effectively as possible. The proposal amends RPC 1.15A, as well as comment 6 to 1.15A. And the proposal also adds new comment 4 to RPC 1.15B. And in amending 1.15A, the proposal adds new subsections K and L. Subsection K provides that when a lawyer identifies unidentified funds in a trust account, the lawyer for 1 year must make periodic and diligent steps to identify the owner of the unidentified property. And in this rule, along with subsection L and comment 6, the proposed RPC amendments expressly distinguish between unclaimed property and unidentified property. Unclaimed property is property where the lawyer can identify the owner but cannot locate the owner with reasonable diligence. Unidentified property is property where the lawyer cannot identify who owns the property. Important to remember, if you reviewed the Department of Revenue memo that we submitted at our last meeting, that the Unclaimed Property Act does not expressly distinguish between unclaimed property and unidentified property. We are making that distinction expressly here in the proposed amendment to the RPC. If after a year the lawyer cannot identify the owner of the property, this amendment would require the lawyer promptly to remit these unidentified funds to the Legal Foundation of Washington. Unclaimed funds still would go to the Department of Revenue as provided by the Unclaimed Property Act, but the amendment to the RPC would require the lawyer to remit unidentified funds promptly to LFW. The rule provides that the lawyer's reasonable and good faith judgment to remit these funds to LFW, consistent with the provisions of the rule, protect the lawyer from discipline for remitting those funds to LFW if later the remission or remittance turns out to have been erroneous. And once the money goes to LFW, LFW will be responsible for it under the procedures and rules that LFW establishes for these funds, except the lawyer may have a duty to seek to claw back those funds that were remitted if the lawyer later learns that the remittance was erroneous or the owner is identified and the lawyer is asked to assist with a request. But LFW still would have control of the funds at that point once the lawyer remits the funds. Another important highlight to keep in mind about the proposal comes out of the new comment 4 to RPC 1.15B. 1.15B deals with record-keeping requirements for trust accounts. And that rule makes clear that the lawyer's remittance of these funds to LFW do not provide any retroactive defense to any violation that led to the existence of unidentified funds in a trust account in the first place, because the reason the lawyer has unidentified funds may result from record-keeping errors. And we wanted the rule to be clear that while the lawyer is protected in remitting the funds in good faith, the remittance of the funds does not retroactively erase any previous record-keeping violations. Those are the highlights we wanted to share, and we are happy to address any questions about the proposal that the governors may have. Thank you.
Does anybody have any governors have any questions for the professor or any of the presenters on this? Governor Couch.
So I apologize if you've kind of gone over this. I'm having trouble kind of tracking though. What would happen to someone's rights to a sheet should they identify themselves later on and this property has not been given back to DOR, but it's been given to LFW, who has hopefully used it?
I might defer to Chair Anderson to school the governors a little more on the doctrine of a sheet in Washington, but my background's criminal law practice. But I think we did discuss that there are some questions about the rights of subsequently identified owners of the property that are not addressed by this rule. The rule was intended to be limited to the duties of lawyers in identifying unidentified property and remitting it within the timetable provided to LFW. And we did not have yet in front of us the rules or procedures for the kind of issue you're identifying of the rights that a third party might have in trying to reclaim those funds. The one limitation is that the rule does make clear that if somebody identifies themselves as the owner of unidentified property and asks the lawyer for help, the lawyer may have a duty to try to seek or request those funds from LFW. But the rule doesn't impose a duty of success on the lawyer because LFW would hold the funds at that point.
Governor Bell.
Thank you, Mr. President. I lower my hand for the moment. Thank you.
Governor McBride.
Thank you, Mr. President. So I understand the proposal draws a line between unclaimed and unidentified property, with unclaimed still going to the Department of Revenue and unidentified going to the foundation. It looks to me like there's still a conflict with how 6930, the statute, defines intangible property. And it brings me to that point of, a court rule and the statute can conflict and the court will first try to reconcile them, or it'll decide, my old simple rule used to be if it was procedural, the court rule prevailed. If it was substantive, the statute prevailed. I'm not sure that's cutting edge analysis, but I do think they conflict. And why isn't the better way to do this to go into the legislature and amend 6930 to exempt this property? There's things in that statute that are interesting, like to Governor Couch's point, the Department of Revenue is going to do a public notice and publication to try to make sure is there somebody out there whose property needs to claim this. And that's not necessarily guaranteed either in the activities of an individual attorney or by the foundation. So it just seems like we could do some of the work of reconciling this by addressing 6930 expressly in the legislature. And so I'm not opposed to the goal. I'm just not sure doing it solely by rule is the best way to go. So if that triggers anything, I'm happy to hear it.
Any other governors have questions, or do we have a response to Governor McBride's question?
Brian, I have a question.
Okay, I don't know if Pam Anderson wanted to respond to Governor McBride's question or no.
Oh, that's fine. I'd be happy just to wait.
I'll be happy to do that, Mr. President, although I'm not sure I have a very conclusive response. And I'm also not sure that I would be the person to refer questions related to a sheet to either. But I will say that if you'll recall the last meeting, the CPE came before the Board of Governors with a pretty extensive memo explaining the steps that we had taken when we were asked to consider whether this rule should be supported by the Board of Governors. And we detailed some work that we had done with the Department of Revenue, and more specifically with its representative, the Assistant Attorney General assigned to that agency. And there is a statutory conflict potentially, and it may be that the Department of Revenue believes there is as well. And so one of the alternatives that we had provided for the Board of Governors to consider was working through the legislative process with the Department of Revenue or through your own legislative branch of the WSBA to try to do that. It seemed to us clear that as a result of the last meeting of the Board of Governors, we were being directed to come up with a proposed rule. And so we took that as a fairly mandate to do that so that in a timely way so that it could be considered at this meeting. And that time frame certainly didn't allow us to do further outreach and develop any potential legislative reconciliations. And nor is it really I think the scope of the CPE's responsibilities to do that. There are other people within the WSBA better suited to that task. But so I guess I have a non-answer to that, which is that we recognize that potential, but we took our mandate to be very specific for this meeting.
Okay, let's see, Governor Higginson, I think you're next, followed by Governor Abell.
Thank you, Mr. President. If by chance I was part of what Ms. Davis just said she took as the mandate, or the CPA took as a mandate, I am very sorry for that. Because I did not intend to send anyone on a wild goose chase by any means, but I'm really concerned. What I remember of the discussion, at least in my mind, was we were concerned about the fact that we didn't have anything definitive from the Department of Revenue. And I myself wanted to know, would they support this proposal or did they have any position? The memo that we have in our materials seems to suggest that from the AG's office that they're still a conflict. And from my standpoint, I'm worried about the language that says the proposed subsection K that would say that a lawyer's reasonable judgment made in good faith about whether to remit the funds to the Legal Foundation of Washington does not constitute a violation of this paragraph, even if subsequently determined to have been erroneous. Well, that might protect us as practitioners from ethical violations, but I don't think it protects us from the Department of Revenue's position that unclaimed funds definitely belong to the state of Washington. And I myself don't want to be in the position of having to make that decision. And if I'm right ethically, but I'm wrong under the Department of Revenue's view of it, they would have an action against me and any practitioner who's in a similar position. So I liked Governor McBride's suggestion or notion that perhaps if we're concerned about wanting to pursue this, it'd be something that we look at amending through the legislature. And that way we all have a very clear understanding. We're not potentially inadvertently caught between our ethical duties and the Department of Revenue's interpretation. And I'll just say from my dealings with the Department of Revenue, which have been numerous over the years on behalf of clients, they are very strict in their interpretation of what monies belong to the state. And I respect that and feel that we should be very cautious in taking a position that might be contrary to what they believe. So those are my thoughts. Thank you.
I think Governor Abell, you are next.
Well, thank you, Mr. President. And as an initial matter, I would like to thank the speakers and the CPE for what you do for the profession and the organization. It's such a fantastic body, and I want to thank you for what you do. On this specific issue, I have not been deep into the weeds on this. I know a number of other governors have, so I apologize if this is sort of a superficial question, but it looks to me like what we have from DOR is their initial statement or position that the proposed rule would conflict with law. And then there was this helpful clarification that was submitted from Megan Chappell to DOR back in September, clarifying that, look, it's not WSBA adopting this, it would be the court adopting this. And so I guess my question is, do we have any substantive response from DOR to that position? Have they asserted whether or not their analysis would remain the same if the Supreme Court were to adopt a proposed rule along these lines. Thank you.
Any other governors? Governor Bell, your hand is still up. Oh, not now. Any other governors have comments or questions? Did any of the presenters want to say anything in response to any of the other governors' comments or questions?
Mr. President, I can respond, I think, to Governor Bell's comment, although I will defer to Professor Holland if I have missed something. But I do not believe that we have had any additional follow-up from the Department of Revenue or the Attorney General's office. We asked at the last Board of Governors meeting whether we should have any further communication with them, and we did not get an answer really to that question. We told them that that this was being handled now at the bar by the Office of General Counsel. And so we transitioned to that. And I don't know whether Office of General Counsel has had communications with the AG's office since that time. And so I will leave that to the General Counsel to respond to that question.
I think there is a memo in box, a confidential memo in box about this whole proposed rule. So if governors have had an opportunity to look at that.
And the CPE has not had access to that because it is attorney-client privileged.
Okay, are there any, oh, wait a minute, hold on. Director Platchey.
Thank you, President Tollefson. My question might be more towards LFW, but it may be towards the CPE as well. This is in regards to the scope of the IOLTA trust accounts. Is this contemplating, or is LFW contemplating that these not only apply to lawyer trust accounts, but to LPO trust accounts, for instance, which have a high volume of IOLTA funds running through them? So I'm just interested, I've heard a lot about the lawyer trust account part of this, but is this also anticipating application to LPOs?
Oh, Catlin Davis has her hand up, her real hand up.
My real hand up, and it's Caitlin.
Caitlin, sorry.
Right. Yeah, my assumption is that this would apply to any member of the legal profession, the licensed legal profession that holds client funds. And so while the specific rule language just addresses the RPCs, it would ultimately be extended to the EL, to the other, rules of professional conduct for both limited practice officers and triple LTs. And if I may, President Tollefson, I just want to go back and I'm not going to speak to the formality of the, state laws and rules about escheatment, but I want to sort of address from the legal foundation's perspective how refunds work and what happens when a lawyer or a bank, under the IOLTA, purview, what happens when the legal foundation of Washington comes into funds where a lawyer or a bank later says that that money belongs to them? Because this happens frequently. A bank will make a mistake on an IOLTA account. A lawyer might leave funds for a few days too long in a pooled trust account when they could have been in an individual trust account. These things happen, and we have a robust refund system in place, along with an organizational value that if ever we are in possession of money that someone else thinks belongs to them, we give it back. And while we have not figured out how it would exactly apply in the issue of, if this rule were adopted and unidentified property, became part of the revenue that we oversaw, we would have a verifiable, approved refund process in place to ensure that, whether a lawyer made a mistake, a client suddenly became available, whether, over the fullness of time, new information was had, we could get the right money to the right people. That's part of our business model. And that's partly why we felt so confident putting this rule forward, was that, we know the refund business. And so I just kind of want to put that to rest. Obviously, there'd be some nuances applied to this program, and we're still looking at best practices at the other states around the country who have adopted similar rules. But that's foremost on our mind as we move forward with this.
Thank you, Ms. Davis. I think Governor McBride has something to say. And then are people not raising their virtual hands anymore? Okay. I'm trying to watch the screen and make sure everybody who raises a virtual hand I get a hold of. So, and we got Chief Disciplinary Counsel Andy, who would also like to talk. Governor McBride, you're first.
Thank you, Mr. President. Just two comments I was thinking about for Governor Abell's question. In my mind, it's a separation of powers argument between the courts and the legislature. So whether the Supreme Court adopts this or not doesn't really answer the question is there a conflict between the rule and the statute? So I don't think that makes it go away. And I, to Ms. Davis's comment, I have full confidence that the foundation would return money. My question is, the issue is whether people know to ask for it. And that's expressly handled in RCW Chapter 6930 with the notice and publication section. It's not expressly handled in this rule proposal before us. So I just think we're talking about two different things, and I don't want to dispute. I actually have a lot of respect for the foundation, but it's that opportunity of somebody to know potentially they have something out there that could get dropped. So I just like the idea of going through the legislature. This isn't an attempt to prevent this from happening. I just think that's a better process to do it with an entity that has a lot more experience dealing with unclaimed, unidentified property. Thank you.
Chief Disciplinary Counsel Andy.
Thank you, President Tollefson. First, I completely agree with Governor McBride that the answer to Governor Abel's question is it doesn't matter whether the Supreme Court adopts this or not. The problem is a separation of powers problem. So the issue remains the same. Second, with respect to Director Plotchie's question about LPOs and potentially triple LTs, please be clear. This is an amendment to the lawyer rules of professional conduct. You do not have before you currently a proposed or suggested amendment to the LPO rules of professional conduct or the triple LT rules of professional conduct. And unless and until those rules were amended, this concept will not apply to those trust accounts. Third and finally, while I have the microphone, I want to draw the board's attention to the companion amendment that I have included in the materials at page 192 that relates to confidentiality of information provided to the legal foundation in connection with the remittance of unidentified funds and requiring the legal foundation to adopt appropriate procedures to handle receipt of unidentified funds. If the board ultimately chooses to adopt this rule for submission to the court, I would suggest that the companion amendments also go along with the RPC proposal. And I say that while trying to be clear that I don't have a position on the policy issues before you of should these funds be held by DOR or LFW. the strategic question of should it be a rule or a legislative fix, the legal issue about the potential conflict between the rule and the statute, and the legal risk to the organization and members of proceeding with a rule change. No position on that, but what I do have a position on is that if the rule is going to go forward, this is a well-drafted rule, and it should be accompanied by the companion amendment.
But right now, as things stand, we don't have a motion.
I do. Is the president asking for a motion?
The president is asking for that. Yes, please. Governor.
I move for the adoption of the rule as proposed.
Is there a second?
Mr. President, I have a question.
Governor Stevens.
Yeah, Governor Adewale, you moved the rule. Do you also include the amendment, since we just heard from Chief
Doug Andy?
Yes.
Yes.
So to move this along, I'll second.
Okay, there's a motion and a second to support the Legal Foundation of Washington's proposed changes to RPC 1.15 and what was the companion rule number? ELC 1527. ELC 15.7. Okay, any further discussion? Looking for those hands. Nancy Hawkins wants to speak. Is it? You have a question? Okay.
And these are questions from me as a member, not representing the family law section. I realized a few minutes ago that I actually was holding unidentified funds for a while this year, which I'd forgotten completely about. And I had the weird experience of getting my IOLTA bank statement earlier this year and seeing $167 deposited into my account from the IRS. It's like, what? First, why? Second, how did they get my IOLTA account number? I mean, this took days of bewilderment to solve. And it didn't get solved till the next month when I got a second payment of $167. Ultimately, I got a third, but by then we'd figured it out. That I had paid a client's debt from some house proceeds pursuant to an agreement, sent a check to the IRS. So somehow my account number got put on their records as the official account. But it took an awful lot of work, literally days, to figure out whose money it was, why I got it. We haven't quite figured out how to stop it yet, but hopefully we've done it now, but maybe we'll see next month. But now that it's been identified, it's been given to that client. So it can happen very innocently. And so that is just a preliminary comment to my real three questions. Does the payment of funds under this motion, if passed, would it trigger a reporting from the Legal Foundation to disciplinary counsel so that it will then trigger a record-keeping investigation? Because certainly the purpose of this is to encourage people to turn these funds over so they can be used. But I think there's a fair number of lawyers that might not want to do that if it's going to trigger a bar complaint, because as the listening tour report tells us people don't like disciplinary investigations or grievances. Second, there was the part of the motion was that if somebody makes a claim, then the lawyer has to sort of assist or, somehow be part of that disclosure, eventually, or that determination eventually that funds are owed to a certain person. But we're only required to keep our records for 7 years. We've heard that if somebody makes a claim 10 years later, they're going to get their money back, but we may no longer have the records to be able to verify that. And I think somewhere in there it says that the lawyer should then make the claim to kind of get the money back. So something about that 7-year record keeping, we need to be absolved from having to keep those records longer, I think. And then third is just my ever popular basic question. There's a memo that you all got about this topic and it's confidential. Why? Shouldn't we all know it so that shouldn't we all see it so we can understand the thought process that goes into this?
Thank you. Let's see, I think Governor Abell, you're next.
Thank you, Mr. President. I will be brief. I want to thank General Counsel Shanklin for the memo. I also want to thank the comments from Chief Disciplinary Counsel Ende and Governor McBride. I'm persuaded by their points. I will respectfully oppose the motion that's on the floor, although I want to say, and I suspect I don't speak just for myself on this, I think this is a laudable goal, but I will respectfully oppose the motion. Thank you.
Thank you, Governor Bell. Caitlin Davis, you have your hand up again.
Yes, again, I would just, in response to the second to last comment that was made, the only agreement, and Mr. Ende, correct me if I'm wrong, but the only agreement that the Legal Foundation of Washington has right now between, say, financial institutions and the WSBA is that if there is a check returned on a lawyer's trust account, that the financial institution must notify the Bar Association. There is no other policy, formal or informal, that we notify the bar or anyone else if there's an issue that comes to our attention regarding a trust account, a pool trust account.
Governor Adewale.
Just a point of clarification, just for those who may not know all of this. This rule is asking that the Bar Association weigh in on this proposal. Regardless of whether we weigh in or not, the Supreme Court will take a decision on this rule, whether it's through us or through any other organization. So what we are doing with this rule is to weigh in on the side of access to justice, so that this fund can be used to help lawyers in all over our states to be able to do the work of access to justice. That is all this is asking for. And there is enough protection in this rule to ensure that if there is any error in terms of whether this should be allocated or not, there is refund, and LFW has a track record of refunding this type of fund. This organization is by far the best in the nation in terms of how it allocated resources. We remember a couple of years ago in 2008, during the funding, during the crisis, that a lot of money was assigned to LFW, for which it was judiciously used across the states. There are lawyers in Central, Eastern Washington, Northeast, Northwest that rely on these funds to be able to do the work of access to justice. So this is what this is all about. It's not about whether this somebody is going to be disciplined or not. It's not, the protection is in there. If you don't weigh in on it, I mean, the judiciary has its own power. The executive has its own power. This is about managing fund to ensure that access to justice is available for all. Thank you.
Any other real or, Governor Couch?
So I had mixed feelings going into this just because I do have the concerns about sheet rules and how this happens and how the DOR is going to view this. But as I'm kind of listening to everything, I realize I don't know that that's necessarily for us to worry about in this room right now. I think, and I'm going to vote in favor of this. I think pushing this onto the Supreme Court is the right thing to do. It helps fund access to justice, taking a very creative use of available funds, which is something LFW is phenomenal at doing. And I think the questions of how the DOR is going to respond is a conversation better had between the courts and the legislature of the DOR, the executive branch, rather than with the state bar. I think we can push this forward as a good idea. And if DOR has concerns, I think amendments need to be made, they will have their opportunity to respond to that. But it seems like LFW has plans in place and is capable of returning funds as necessary, of dealing with these issues as they come up. It also seems like a very low risk situation considering they are talking about unidentified property, not just unclaimed property. So I'd urge you guys to support it.
Okay, Caitlin Davis, you have your hand up.
One last comment.
Okay.
Our plan is to submit this to the Supreme Court, and we hope the WSBA will join us. I anticipate, just with every other rule proposal or rule amendment proposal, it will be published for comment. And I just want to appreciate the last comment that was made. There's time ahead in front of us for the Department of Revenue to submit comments. They've submitted one, but it will be published for comment. Let's just, if you agree with this in theory, as has been shared by 3 governors now, let's just put it forward and let's ask the court to take a look at it. That's all we're suggesting. Thank you.
Any other virtual hands or real hands? I don't see any. Okay, I think we're ready. Does anybody want me to restate the motion, or does everybody have it in mind? I think everybody has it in mind. Ready for a roll call vote? Governor Abell.
No.
Governor Adewale.
Aye.
Governor Angeville.
Aye.
Governor Boyd.
No.
Governor Clark.
No.
Governor Couch.
Aye.
Governor Dresden.
Aye.
Governor Higginson.
No.
Governor McBride.
No.
Governor Peterson.
Abstain.
Governor Pertzer. Governor Sayani.
Aye.
Governor Stevens.
Aye.
Governor Williams Ruth.
Aye.
I'm counting 5 yes, 7 yeses, 5 noes, 1 abstention and 1 not voting. Is that what everybody else has?
Yes.
Motion carries. Okay. Thank you very much for this presentation.